Hello, my name is Attorney Justin Camper. Good morning, good afternoon, good evening, whatever time zone you are in. I am wanting to talk to you about a very important legal topic within the criminal justice system, so you better stay tuned. Oftentimes I hear from people and they say, hey, the trial is over with, the person has been convicted. We've tried to appeal the case. Is there anything else that can be done? Well, the answer is yes. You can actually file what they call post-conviction relief. Post-conviction relief is a legal method that you can use to file to get your case overturned, reversed, get a new trial. Several factors and several things can happen once you file a post-conviction relief. So let's talk about it. I'm going to give you a short version of it, what happens, what exactly is post-conviction relief, how the process goes, what happens if post-conviction relief is granted, and, what are the next steps. So let's talk about it. What is post-conviction relief? So post-conviction relief is, in simple terms, it's a legal process that's used to get the courts to re-examine your case. It has to be re-examined for certain legal reasons, right? It can't just be re-examined because you just want to re-examine. We would have to challenge a conviction based off legal reasons that are there's a basis in law that they have laid out that these are the reasons that your case can be, granted post-conviction relief. So you might be thinking, well, isn't that what an appeal is for? Not exactly. An appeal is about what went wrong during the trial. It could be there was improper evidence. It can mean that there was improper jury instructions, right? But post-conviction relief is a little bit more deep. And we're going to talk about the reasons why post-conviction relief can be granted. Number one of the reasons why you can get granted post-conviction relief is ineffective assistance of counsel. That basically means your lawyer didn't do his job correctly. Maybe there was evidence that he didn't present, or he didn't show for court proper, prepared, or ready. It could mean that he didn't call key witnesses, or just some critical mistakes that every attorney should know. That is called ineffective assistance of counsel. You can file that in your post-conviction relief and be granted post-conviction relief. Another reason why you may be granted post-conviction relief is newly discovered evidence. There's something that came out after the trial that's so critical that if it was there before trial, the case would have been overturned. So that's another reason. The third reason is prosecutorial misconduct. Doesn't happen often, but it does happen. And prosecutorial misconduct is when you have evidence that the state did something illegal, they withheld evidence, and that could be granted a reason why post-conviction relief can be granted. Another reason why post-conviction relief can be granted is for constitutional violations. So if someone was forced to speak at their trial, every defendant has a constitutional right to remain silent. And let's say the judge says, I want you to talk. I don't care. I want you to talk, right? That could be a reason for post-conviction relief. Number 5 is, which we're going to probably see a lot more of, which is changes in the law. So something that was once illegal is now legal. You can ask for post-conviction relief. You're going to see a lot of this when it comes to particularly the marijuana situation, because marijuana is becoming legal throughout states. And, there are people in jail having marijuana, so they can ask for post-conviction relief. So now that I explained to you the reasons why you can have post-conviction relief granted, let's talk about the process. So first, number 1, you would typically hire an attorney, and that attorney will file a petition with the court, and that attorney will outline the reasons why your case is deserving of post-conviction relief. Then the state would get an opportunity to respond to our filing, and they would typically give reasons why we're wrong and why the conviction should stand. Then there will be a hearing. We'll go in front of the judge. We'll make arguments. It's called an evidentiary hearing, where we make our arguments, and the judge gets to decide on who he wants to believe. And then, the final thing is just the judge's decision. The judge decides, after hearing all the evidence and the witnesses that we will present as criminal defense attorneys. The state will present their evidence, their witnesses, their argument, and the judge will make a final call. So the next question I get when clients are trying to hire me for post-conviction relief is, well, how long does this take? Well, it really depends, right? It depends on, now I'm talking to a general audience here, so it depends on whatever state you're in. We're located in Indiana, but it depends on, your state, your local rules. So you really gotta talk with your attorney on that. It's really hard for me to make a call without seeing your specifics of your case. But it's not an overnight thing, right? It doesn't happen right away. I would say give yourself at least 60, 90 days of a process for your attorneys to review transcripts, to really gather all the evidence. But it's not a quick thing. So if you're looking for a quick thing, resolution, post-conviction relief may not be the way for you. So make sure you consult with a criminal defense attorney before you make that call. So now you know what the reasons for post-conviction relief, you know how the process is, you know how much time it could typically take for post-conviction relief to be granted. Now let's talk about what happens once you are actually granted post-conviction relief. So number one, the best solution and the best thing that could happen is that your conviction gets reversed, meaning that you are no longer convicted of whatever the conviction was, and you're basically innocent at that point. Number two is what typically happens, which is called you get a new trial. So you just start from the beginning. Now you're fighting again. Judge says, hey, that trial is out the window. We're going to give you a new trial to fight your case. Number three is that the judge could reduce your sentence and say, hey, you've been in jail for a long time. Because of this case, I'm going to actually reduce your sentence and set you free. So basically, that's a resentencing can happen. He can reduce the penalties. He can resentence you in a way that he feels is more appropriate based off the evidence in the post-conviction relief that will be presented based off with your criminal defense attorney. So this is a very unique way to challenge your case. It requires crafty legal strategy. It requires really understanding the law and understanding how it works. I see a lot of clients often try to do PCRs or post-conviction relief by themselves. You know, I definitely recommend that you have your public defender or hire an attorney to do it so you won't lose on the complications of the case. So I hope that this is helpful for you. I would love to hear from you, get feedback from you. If you're looking to, you know, possibly do a post-conviction relief for one of your convictions, let's talk about it. But if there's some topics that you want me to cover in the future, please put in the comments. I want to continue to provide you guys with great criminal defense strategies to help you or your loved one who may be facing criminal charges. I work for Justice Capital Law. That's my law firm. And our mission is to help all of our clients avoid jail and reclaim freedom in their lives. So you have a great, productive, blessed day. Stay informed and always remember, stay legal. Looking forward to seeing you in the next video.